SJC-13722, Commonwealth versus Michael J. Wurtzberger.
Okay. Attorney Henry.
Good morning, Your Honors. May it please the Court. Genevieve Henrique for Mr. Michael Wurtzberger. I also have at counsel table Matthew Schmidt, Attorney Matthew Schmidt, who was trial counsel. Today before you, we have the case of Commonwealth v. Michael Wurtzberger, where my client was convicted of operating under the influence. This court indicated interest in discussing more as to whether or not the evidence was sufficient to sustain that conviction, particularly on the issue of operation, and I suggest that it was not. First, before we get into the case law that could possibly support or not support that conviction, I'd like to turn to the facts. I think that's important to guide today's discussion. What we had here was a situation where we had two individuals, two buddies, camping, fishing, staying in a U-Haul van in a beach parking lot in the town of Bourne. They'd been there for several days, according to the civilian witness. There was camping equipment strewn around the van, inside the van. They were cooking out of the van. They were living out of the van. The only evidence that could support and survive a motion for a directed verdict in terms of operation is that when the officer potentially survive, and my argument is that it didn't, but that where the court needs to focus on, I would suggest, is that when the officer approached the U-Haul truck, these two individuals were sitting in the front seats. My client was in the driver's seat. The keys were in the ignition, engine was not turned on, and the radio was playing. Now, I expect...
Excuse me, hold on. The truck was also parked so close to a tree that one couldn't open the door, correct?
It was, and I was just going to point out that I expect you'll be asking me questions about the position of how this van was parked. And there could be a lot of speculation as to how the van got there. Let's take it in light most favorable to the Commonwealth. The suggestion that my client drove it there, got himself into a situation, got into the driver's seat, drove it there, got himself into a situation where he realized he couldn't get out.
Well, there's the other part of it too. There's that he can't ambulate over the hump. So he's like Winnie the Pooh in a tree, right? He's
Potentially,
stuck.
or he got there. Before we even go into that speculation, though, when did he become intoxicated? Does that speculation survive the motion for a directed verdict? And I suggest it doesn't, and the trial judge specifically put it on the record, and the Commonwealth points out in their brief that the reason she denied the motion was because keys, her specific words were, if I may, he's in the driver's seat with the keys. Those were her words on the record, and it's in the Commonwealth's initial brief. And that is what she based it on, because whether he was the one, again, in light most favorable to the Commonwealth, let's say he did move that car and put it up against the tree. We could talk about the circumstances, the real life circumstances of have we done that? Have we gotten closer to a car? It came up on the appellate too close to a car, and we realized, oh, and do you remaneuver it? But again, this is at 4:30.
You have to maneuver the car in order to operate under the statute?
No, okay. I think, though, what potentially would be suggested is if my argument, or my client's argument, that keys in this circumstance, that the keys in the ignition with the radio playing is not enough for operation, well, do we have evidence of other operation? Driving while impaired. And my argument is that no, the only evidence of operation that we should even be looking at all while the defendant is impaired is that that he was seated in the driver's seat, keys in the ignition, radio on. Because
so you don't think that there was a reasonable inference from the fact of the wonky parking job that he did it while impaired?
I do not, because first of all, I'm not so sure I'd suggest it's wonky outside of the fact that, yeah, he's close to the tree. But again, we don't know when we've done that. We've gotten close to a car. Maybe he'd be moving it after, maybe not. But again, there's no intent. We have no idea when that van last moved. This is at 4:30 in the afternoon. They have been there for several days. Yes, there's evidence, there's testimony that they go in and out of the truck, but absolutely none as to when that truck maneuvered to there. And
but
so
isn't that a jury decision?
Yeah, I would suggest no, there is it's so tenuous. There's nothing on the record whatsoever as to when they started to drink. And so, no, I would suggest that that does not go to the jury.
Well, I mean, if you're only looking at one side of this, right? So the Commonwealth, in having to prove its burden at trial, they're going to have the police officer that was there. Presumably that police officer is going to be cross-examined as to all of these things. You don't know when that truck was put there. You don't know what they did. So why isn't that quintessentially the factual determinations that jurors are there? And specifically, you're asking us to do this in the lens of the required finding. So we are in Lattimore, we are in the light most favorable to the government. So why isn't this?
But I'd suggest even in the light most favorable to the government, there needs to be some evidence as to when the intoxication started. A statement by the defendant, if we've been drinking all day. I mean, clearly my client didn't argue that he was intoxicated. Some sort of statement, we've been drinking all day, or, oh yeah, the beers got warm, so we switched to the vodka. Something, there's nothing. There's nothing as to impairment, the timeline of impairment.
Okay,
I would suggest there has to be something.
Even under the totality of all the evidence that was in there, you know, back to Justice Graziano's point, he couldn't get over the hump. There's the bottle of vodka that's there in the well. All of that should be divorced from the discussion of operation?
Yes, I would suggest without some sort of timeline as to when the impairment began.
And so are you asking us to create a new rule, or do you have some case law or something that supports your proposition?
I don't think that is a new rule. I think that there's just nothing, there's no evidence suggesting when the imbibing began. The record is completely
They're
devoid.
two separate questions, right? One is whether he operated and set in motion the mechanical, and I think having keys to ignition, he's got a problem. But the nexus between the drinking and the operation is something the Commonwealth also has to prove.
The
intoxication
right.
and the...
And so if this court were to focus on that initial scenario of alleged operation, I would suggest that the nexus is there is no nexus there. And so therefore...
It's every other case when the police come upon someone passed out in a car.
It is every other case, and then we discuss as to whether
And then they
those
say, I
are
started
incident-
drinking when the car broke down.
When the car broke down. And a lot of those cases, though, which are still clearly incidental to operation, because a lot of those cases where we have Commonwealth v. Hilton, we have cases where clearly somebody has driven to a point where they realize that perhaps they shouldn't be driving. They've pulled over, but they're still very close to a roadway. They have not maneuvered to a safe spot. They're not in a rest area, where it's been suggested that maybe somebody, and certainly other jurisdictions, which I can get into, recognize that, okay, somebody's gotten to a safe spot, they're there for the night, they have no intent to drive this vehicle further. And that's where I'd suggest we're at with this case, because I would suggest that what we have for the facts that we should be looking at are person in the driver's seat, yes, impaired, yes, keys in the ignition, radio on. That's what and from there, I would suggest we move on to looking at this fact-based scenario and whether or not that is enough evidence of operation to have gone to the jury, and that the facts supporting the operation at that moment in time are so de minimis as to fly in the face of the common doctrine of fairness that these cases aren't decided in a vacuum. And I think that's ultimately would be my client's point. Where are we trying to go with the body of case law that is essentially antiquated and unclear since the 1920s? That's pointed out in the concurrence of this, the appellate court opinion, that there's very little guidance, and perhaps it's time for more, whether it be from the legislature or this judiciary, that what behavior are we looking to criminalize? And are we looking to have a strict liability analysis? Or are we looking...
Tell us how we improve our operation instruction.
I think there's a survey of other jurisdictions that can be done to look at what they have included in their analysis to bring in an element of fairness as opposed to strict liability, because again, I think it's really important to look at the behavior that you're trying to criminalize, or because behavior that could potentially endanger the public versus behavior that's not going to. And that's actually what the word
Usually
that-
it's actual physical control of the vehicle.
Actual physical control of the vehicle is the standard that's used in a lot of states, but then even that is interpreted differently among different jurisdictions. So there are just jurisdictions that use actual control of the vehicle, but then still, and some treat it more as a strict liability standard, while others, the words I just used, which, and granted, it's maybe one of the most more liberal of the analyses, but Arizona looks at whether there's been an actual threat to the public, and that's directly in there, whether there is an actual threat to the public, and given the circumstances of the arrest, and that's directly in their jury instruction. We also have, for just example, and I can certainly get back to this, I won't harp on the different cases yet, but Maryland, I think is somewhat similar to what we're talking about here, where they will consider whether somebody's using a vehicle as a stationary shelter. And I think that's looking at the different case law, the different jurisprudence from other states is particularly important in this juncture that we're at in 2025, because we know that times have changed quite a bit since 1928, when a lot of this case law started being, that's kind of when this is rooted with Clark and Uliski, where we have recreational vehicles, we have key fobs, we have driverless cars, we have phones that apps start the car. For one example I was thinking of as I was trying to think of examples and as point out to the court why I agree with the concurrence that the case law needs to be clarified for purposes of fairness going forward, is because there are so many, they might seem like crazy scenarios, but some were even thrown out during our appellate argument of, what if you have a 15-year-old sitting in your car, and perhaps I have a 14-year-old at home, she plays with my phone all the time. I mean, she has her own, unfortunately, but she'd say she's sitting there, she's waiting for me, she pulls up the app of my car, and she can certainly start the car, or she can start a lot of different mechanisms. We have a colleague who comes outside of the Superior Court and has his Tesla drive up to him if he walks out of a bar. When does the operation start? Is it when he starts?
Doesn't
clicks?
that, as a defendant, doesn't that actually hurt you?
I
mean, doesn't that make it easier to operate the car if you're under the influence that you can do all of these things without physically putting a key in and manipulating an ignition?
That's the problem, Your Honor, because we don't know when does, so under this in this modern era, when does operation start? And that's the problem. We don't know, and isn't that the idea of the law needing to be clarified?
I suppose you're talking about where we ought to let the puck go, but we're talking about this case.
Right.
And even though you cited Justice D'Angelo, he agreed in affirming your client's conviction. So it wasn't as if he dissented on the case. So I'm just still wondering, under our current existing case law, what's your best case for the fact that operation here should not have gone to the jury under the Lattimore standard? Just what's your best case?
I would say it's a combination of Plowman and Carvalho opening up that the facts surrounding the case do matter. And that in this case, again, the evidence was so de minimis that the interpretation of the case law ended up being a strict liability analysis when it never should have been. And the judge ended up putting forward to a jury behavior that the judiciary never intended to criminalize.
Thank you.
If I may just point out a few other of the, I would suggest ways that very briefly, that some other jurisdictions have looked at it. And then in the meantime, if there's questions about that, and if not, I will cede. I think it's important to recognize that other jurisdictions have examined this element, and Illinois recognizes that safer highways might mean giving people the ability to sleep it off. People v. Cummings being the main case there. In Alabama, the jury instruction allows for looking at surrounding circumstances. Arizona, we've already spoken to. Utah recognizes that there could be a passive occupant, including somebody in the driver's seat. And then Colorado looks at everyday experiences. Again, that's what I'm asking the court to apply here. And New Jersey, under State v. Daly, certainly includes the element of intent. So again, what I'm looking at here, what I'm asking the court to do is not just look forward, though I do think that's important, and in reality, it was what was brought up by the concurrence. But finally, I would suggest that while it's a suggestion of the appellant that the case law guiding what constitutes operation be reviewed, clarified, and updated, given the modern times, it's also as contention.
Counsel, can I just interrupt you one time before we leave? Even if we agree, one thing I didn't see in your brief, would your client get the benefit of any new rule that we would announce?
Most likely a new rule would not be retroactive, and we understand that, and that's why I'm saying yes, it is. We are asking the court to do exactly what was asked by the concurrence. We are also, though, not conceding that at that time, at the time of the trial, the case law, by the very idea, the principle of fairness, that should not have gone to the jury because it was looked at in a vacuum as a strict liability standard. Whereas, in fact, we had two buddies fishing in a parking lot, no intention whatsoever of moving that vehicle. We all know it from common experience. From our own experiences, we look at those facts. So again, is that the behavior we're looking to criminalize? If there's no other questions, I will. Thank you.
Okay, thank you. Attorney L. Curry.
It is still morning. Good morning. May it please the court. Rosellen L. Corey for the Commonwealth. The Commonwealth maintains that there was sufficient evidence of operation by the defendant in this case in order to convict him of operating a motor vehicle under the influence of intoxicating liquor. We maintain that the trial judge properly denied the defendant's motion for required finding of not guilty, and that the appeals court properly upheld the decision.
Can I give you just putting aside the Winnie the Pooh point, if we didn't have that, we just had these, homeless family parked in this parking lot, and the ignition's on because it's cold, and they're drinking in the car. Still a conviction, right, in your view, right, for OUI?
Well, is the theoretical 15-year-old the one sitting behind the wheel, or is it the?
I'm positing. I've got, a single parent in the car. They live in the car in the parking lot on Cape Cod, and they're having some wine in there too. But that's because it's their home. I'm just trying to get a sense if they've turned on the car key to warm up the car, right? Under our case law, I guess we convict them, right? Or do we not? I just don't. This is not an area of expertise.
Under the current case law, I would say that would be a conviction that would survive at least the appellate court.
Is that kind of is that a good thing? Go ahead.
I wouldn't concede that point. It's an element-based charge. It might be enough to satisfy operation, but there's still other elements that need to be proven in order to get a conviction. So I think we.
Which are those?
On operation on the public way, and that, but all of those other.
I'm contemplating it's a parking lot that's connected to. Cape is filled with those parking lots, right connected to the road. I'm just trying to get a sense of, do we convict those people or not?
As Justice George has pointed out, there are other elements that the Commonwealth does have to prove.
There's the public way, there's operating, and there's drinking.
Yes.
The key gets you up. I'm interested in the key point. It's just, especially nowadays, number of cars, you just walk in with your keys, the car goes on.
And other jurisdictions have considered that. I think it's Connecticut actually that State versus Sear, I believe, is the case where
on the fob,
where they did consider someone who had remotely started his vehicle, and I'm actually not sure, which is a shame because I was just looking at it, whether or not he physically entered the vehicle, but they did specifically discuss the fact that it is not the order in which a person places himself in the driver's seat and then starts the ignition. If he starts the ignition and then places himself in a driver's seat, for us, that is sufficient to start operation. And the defendant
But
in
it
that,
just, again, that's the person who turns the heat on the car too, right?
right, it is.
A lot
And,
easier to turn it on from the driver's seat.
From the other place.
well, and I think the rhetoric, both in Massachusetts and in other jurisdictions, is that the point is to discourage people who have been drinking from getting into the car except as passengers.
I get that. Is there any, again, back to Justice Gaziano's question, is there a way we can improve our case law in a way to, not punish the sort of homeless person living in the car?
I would agree with defense counsel that their strongest case is probably Plowman, in which the court did remand a decision specifically because the instruction that the judge gave made it seem as if the jury had no choice but to find operation in the case. And in that case, the defense had been, it's my girlfriend who came home and left the car running so we could bring groceries in. I had been drinking. We got into an argument. She was going to go out and drive the car. I didn't want her driving while she was upset or drunk or whatever. And so I moved her out of the driver's seat into the passenger seat. I sat in the driver's seat so that she couldn't, and then we both fell asleep because it was late at night and I'd been drinking. So the court in that case did say, considering the circumstances there, obviously there was a defense to be had based on the surrounding circumstances and the intent before the defendant in that case entered the vehicle. I think that we do have the instruction, and it was employed by the judge several times to not leave our common sense behind when we enter the jury room and to rely on common experience. And I do think that, in the scenario where it is a homeless family and there may be other issues, common sense does come into play. And I think in this case also, common sense does come into play. And I think it does suffice to sustain operation. But in terms of improvement, potentially adding clarifying language to a jury instruction to specifically instruct the jury to consider all circumstances.
I think it's the mouthful that talks about mechanical or electrical agency, which alone or in sequence will set in motion the motive power of that vehicle. I don't really know if that speaks to the jury anymore.
I would say it does. I would say that despite the technological advances.
Have you ever used the phrase motive power of the vehicle in plain conversation?
I'm in my plain conversations as a prosecutor for the Commonwealth. Yes, but I have.
When you're with your friends?
But no, my friends won't tolerate it. It's with my family because they're literally a captive audience. But
you think we could probably do a little bit better than that?
I genuinely, in that circumstance, I do think it's clear what is being articulated. It is steps that you would take to put, whether it's a Model T and you're using a hand crank on the outside to start the motor, or it's a Tesla and you're remote starting it from, within your office building. You are taking steps to put the motive power of that vehicle into operation.
What does motive power mean? Having not done these, what does motive power mean?
I would say it's the
Does
motion.
it mean moving?
The car put in motion, or does
Yeah.
it mean turn the engine on?
So that would put the motive power in. So I take it to be steps that would get the car moving.
So it's engagement of the ignition, right? It's turning the key, is a step towards the motive power.
Yes.
Which makes liability.
Yes, and whether it's turning the key, one spot to turn the radio and the heat on and just engage the electricity, whether it's pushing a button without.
But
putting
isn't
your-
it the same?
Sorry.
Isn't that the same? That most of the time,
That thing that
Right,
turns
there's the
on the
first-
heat or turns on the music satisfies the motive requirement, right?
Right, and I would agree with that because how
does that definition help in the camping situation or someone that's at a concert in the parking lot and they turn the radio on?
Well, I think in that circumstance, it does come back to whether or not this is still a motor vehicle that this person who has been intoxicated and is now presumably sitting in the driver's seat could move down the road and potentially harm others. It was interesting to hear defense counsel bring up Arizona, because they actually had language that I found to be helpful in State versus Love, which is 182 Arizona 324, a 1995 case, where they say basically the obvious statutory aim is to enable the apprehension of a drunken driver before he injures or kills himself or another person. That's the purpose of this statute. So whether or not, you are sitting behind the wheel of your car that is still a functioning vehicle, that still has gas in the tank, that can still move, and you only have the radio on right now, you're intoxicated, you're behind the wheel of a car, and you've taken steps to put that car into motion. Those elements haven't changed in 100+ years. Technology has changed. People haven't changed that much, but the basic functions are still the same. If there are no other questions, the Commonwealth would rest on its brief.